In Chapter 21, we're going to look at investor protection, insider trading, and corporate governance. The Securities Act of 1933 governs the initial sale of stocks by businesses. It's designed to protect investors from deceptive, unfair, and manipulative practices when buying or selling securities. Securities are generally instruments such as corporate stock or limited partnership interests that evidence an ownership or debt. Under the Howey test, it's any transaction in which a person invests in a common enterprise reasonably expected to have a profit and derive primarily from others' managerial or entrepreneurial efforts. If a security does not qualify for an exemption under Section 5 of the Securities Act of 33, the security must be registered with the Securities Exchange Commission, or SEC, and state securities agencies before offered to the public. That's the purpose of a registration statement. A corporation must file this registration statement and prospectus with the SEC. That prospectus is later distributed to the investors. It includes the securities being offered for sale, including the relationship to the issuer's other capital securities, corporation's properties and business, including financial statements certified by independent public accounting firm, management of the corporation, how the corporation intends to use proceeds of the sale, and any impending lawsuits or special risk factors. A registration statement doesn't become effective until it's approved by the SEC. There's a pre-filing period where the issuer can't offer or sell securities, a waiting period where securities can be offered but not sold. A registration statement does not become effective until it's approved. There's also a post-effective period where the registration is effective 20 days after approval. There is such thing under the Securities Act as a well-known seasoned investor, and that's a firm that has issued $1 billion in securities during the previous 3 years with $700 million in value outstanding. Here are some exempt securities and transactions. Also, exemption would be Regulation A offerings, a small offering up to $5 million in a 12-month period to test the waters. It does require a circular. Regulation D, there are different rules under Regulation D for small offerings, up to $1 million during 12 months to accredited investors only. Private offering up to $5 million during 12 months to both accredited and unaccredited investors, and the private placement exemption. There's also Rule 144 and 144A covering resales and safe harbor rules. The 33 Act also has penalties for violation if there's intentional or negligent fraud of investors by misrepresenting or omitting material facts in the registration statement and or the prospectus. Remedies would include up to 5 years in prison, $10,000 fines, civil damages, a refund of investments, an injunction. A defense would be that the statement left out was not material, or the plaintiff knew about the fraud and purchased the stock anyway, or the registrant believed the statements were true. Securities Exchange Act of 34. This is involving the registration of securities exchanges, brokers, dealers. National Securities Exchanges Association requires a continuous disclosure system for corporations with securities sold on national exchanges or assets in excess of $10 million and 500 or more shareholders. So while the 33 Act governed the initial sale of securities, the 34 Act governs registration of securities exchanges, etc., and operations of those exchanges. Section 10B, Section Rule 10b-5, and insider trading. Section 10b prohibits the use of any manipulative or deceptive device or contrivance in contravention of rules and regulations of the SEC. Rule 10b-5 prohibits the commission of fraud in the connection of the purchase or sale of any security. Defines insider trading as advanced information available to corporate officers and directors that can affect future value of stock. Insiders would include, under 10b-5, officers, executives, and directors. A material omission or misrepresentation can violate the 33 Act and anti-fraud provisions of the 34 Act, as well as SEC Rule 10b-5. In terms of disclosure under SEC Rule 10b-5, the key is whether the information is material or not. There are also outsiders. If there's insider trading, there are those who are not insiders. There's the tipper-tippee theory, where the outsider is tipped off about something that's not public, and an insider has a fiduciary duty that needs to be breached. A misappropriation theory, where someone wrongfully obtains insider information and trades on it. Courts still require the fiduciary duty to be breached to the employer, for instance. There's under 16b, there's the allowance for recapture by a corporation of profits during the previous 6 months gained by insider trading. This applies to stocks, warrants, options, and convertible securities. There's also the Private Securities Litigation Reform Act of 95. Provides for safe harbor for publicly held companies that make forward-looking statements such as financial forecasts. And there's also regulation of solicitation of proxies. Whoever solicits a proxy must fully disclose all the facts and which shareholders must vote. There's a scienter requirement in the 34 Act. It can be proved by showing the defendant made false statements or wrongfully failed to disclose material facts. Under 16b, it's strict liability. There's no fault or scienter requirement. Criminal penalties include imprisonment up to 10 years, fines of up to $5 million, and $2.5 million for the partnership or corporation. Civil sanctions include up to triple profits. There's also state securities laws. These are often called blue sky laws. So issuers must comply with both federal and state securities laws. States do not allow the same exemptions as the federal government does. A state could also require registration or qualification. The Uniform Securities Act, much like we'd have UCC or Uniform Partnership Act, this is an attempt to adopt uniform statutory law across multiple states. Corporate governance is essentially the relationship between the corporation and its shareholders, or attempting to align the interest of officers with their shareholders, and they can do that through things like stock options. The goal is to promote accountability, and involves at a minimum the things listed here: audits, specific rules around governance, legal protections for shareholders so violators of law can be punished. Some of you may have heard of Sarbanes-Oxley. This act attempts to increase corporate responsibility by requiring stricter disclosure, harsher penalties for legal violations, forcing corporate officers to take responsibility for financial statements and SEC reports, and the CEO and CFO must personally certify these reports. Requires more internal controls and accountability. There are some exemptions for small companies, and there's a requirement for certification and monitoring. This all avoids that ignorance defense, the argument that the CEO is not knowledgeable or too busy to know what's going on in the accounting area. You also can have online securities fraud. The SEC is enforcing anti-fraud provisions of the securities law. This would include things like online investments, scams, fraudulent emails, online investment newsletter forms, Ponzi schemes, offshore fraud.